Good afternoon, ladies and gentlemen. My name is T.R. David. It's a long name. It stands for Talakkottur R. David. I'm a US citizen as well as a United Kingdom citizen and have been living abroad for nearly 50 years. I'm currently in India since 2011 on a self-imposed exile. Once you listen to this tape, this recording, as well as the previous recordings in the matter of David versus AT&T, you will know why I am here. In further continuation of video number 1, 2, 3 and 4, this is going to be possibly the last and final video in the matter of David versus AT&T et al. This litigation lasted nearly 34 years with no end, no beginning. It reached nowhere. And I'm going to talk to you what happened, how the gimmicks played in the courts by the powerful law firms in concert with federal judges and other officials, including the officials of the Department of Justice. So, before I begin, I just wanted to fill you what really happened. I was born and brought up in India, went to law school and colleges in Delhi, India, went to England subsequently, had 3 girls. We eventually migrated from England to America. I started my first day, the very first day I entered the United States, as a clerk with a company called Michigan Bell Telephone Company located in Detroit. Michigan Bell at the time was a subsidiary of AT&T. AT&T stands for American Telephone and Telegraph Company. After working there nearly 6 months, my immediate boss found me way overqualified. He asked me, I and my family and 3 girls who were all British born came to America, and I started the very first day in Detroit, Michigan, with a company called Michigan Bell Telephone Company, a then subsidiary of AT&T. AT&T stands for American Telephone and Telegraph Company. The ticker symbol for AT&T is plain T, T like Tom, that you can see in the New York Stock Exchange. If you type T, TE means American Telephone and Telegraph Company. And the present company is the grandson of the original AT&T. I just wanted to caution all of you, those who are listening, the original AT&T is known as Baby Ma Bell, and the new AT&T is the Baby Bell. I wanted to just give you a brief background. I started with the Michigan Bell. After 6 months working, my boss said, Mr. David, you are way overqualified, come over here, let us discuss. I told him when I was in India, I used to work for an insurance company in New Delhi and also worked part-time for the retired Chief Justice of India, Dr. Teja Singh, at his home. The short assignment. That was my experience, and I told my boss I also worked for the British Post Office in London, and I had received during the 6 years I worked there 2 commendations and cash award from the British government for catching a bunch of thieves who were printing pension books and also bank books and cashing from different offices. I got both sets. So I got a commendation and cash award. Later on, we went to America with my 3 daughters, Rosalind, Anne, and Julia. As soon as I landed there, I got a job, as I told you before, and I was found way overqualified. They sent me to work for a male boss as his secretary. This guy said, no, I don't want a male as my secretary. He wants only young chicks or young girls. Later on, the Central Personnel Department insisted that this guy takes me as his secretary because I'm qualified test-wise, experience-wise, and qualification. So he hired me, and within a week he said, you are not fit to do my job. I was sent to work for this male boss who had no option but to hire me. But within a week he said, Mr. David, you are not fit to do my job. You have to go back to the department you came from. I had no option. When I went there, people told me, Mr. David, we have an EEOC office, Equal Employment Opportunity Office, within the company. I go there and tell them this is the situation. I went there, they told them, Mr. David, this guy is 4 levels above us, so we can't investigate him. You go to the outside agency created by the US Congress. That's called Equal Employment Opportunity Commission. I filed a complaint with them. They investigated. They found the employer is in violation of the Title 7 of the Civil Rights Act with regard to national origin, gender, and so on and so forth, and ordered the company to reinstate me and pay me compensation. They paid me a small monetary compensation, a token payment. They took this as a grudge against me. This is the beginning of the problem for the last 33 years of litigation. Thereafter, while working for a German and a French gentleman as their secretary, I was again found way overqualified. Then 2 more new managers came by the name Hank Hodgson and Bob Cooper. They too found me, I'm way overqualified. Mr. Hank Hodgson recommended that I go for a management training program or management assessment program. I went there, which was a 3-day program at which I got a score of 10 out of 10. As is the practice with the company, anybody who scored that high is immediately sent for intensive management training for 3 years. But in my case, as a retaliation, they failed to even disclose to me my test result for 1 year until I forced them to do so. During a meeting with the personal department person by the name Mr. Shepard, he said, Mr. David, you got a score of 10 out of 10. That doesn't mean you are promotable. You are never going to be promoted. That was his exact words. So I know this is definitely a retaliation for my filing a previous complaint. I filed a second charge of retaliation. This time, my immediate supervisor was the US attorney's wife, which I didn't know her husband is the US attorney. I went to the US Department of Justice to complain about the employer's conduct. And when I walked into the office of the US attorney, the photo of the woman was on his desk. So I decided not to complain. When I got back, my immediate boss, who is the US attorney's wife, called me and said, Mr. David, we have an opportunity for you to work in Orlando, Florida. Are you interested in? I said, fine. I was sent for an interview. I was hired by them. I was one of 1,500 employees selected by AT&T from their subsidiaries to work on various antitrust cases brought against them by the US Department of Justice and others. While working there, we were told we have all the benefits. We were given all the moving cost and expenses. They reimbursed us the cost of moving my 2 cars, household furniture, everything like others. No problem. We were told the employment with AT&T will be for a period of 5 years. After 2 years, the US Department of Justice and AT&T agreed for the breakup, and as a result, AT&T wanted to get rid of these 1,500 people working there. We were called and offered us various options. The company said, we will give you 3 years salary if you want to quit the job. They call it a golden handshake, plus the pension. Those who want to go back to the companies they came from, they can do so. You can also go for another foreign company if there is a vacancy within the Bell system. I opted for Saudi Arabia. Also, my first preference was to go back to the company I came from. The company fulfilled the terms of their promise to several people, but not others. They offered me some money, $35,000 to quit the job. I said, no, I don't want to quit the job. The next day they offered me and my wife, who they requested I bring for an interview. During the meeting they offered me $45,000 to quit the job. I said, no, I don't want to quit the job. The gentleman who called me for the meeting, his name is Mr. Stone, Richard Stone. He said to me and to my wife, Mr. David, you are fired. You are fired. For what? No legal basis to fire me. In fact, 1 week before my illegal termination of employment, this company had given me $5,000 semi-annual merit increase and a fully satisfactory job performance rating. So there is no basis at all for the company to fire me in flagrant violation of the laws. There are several laws they violated. One is age discrimination in employment, in retaining younger workers, firing me. Title 7 of the Civil Rights Act, which said an employer cannot discriminate because of your national origin, color, or gender, and blah, blah, blah. And third, without giving me my ERISA benefits, Employees Retirement Income Security Act. These are the 3 laws upon which I sued these companies subsequently. After firing me, myself, my father, who was then dependent upon me, is now dead, and my 3 daughters and a newly born son, Dr. Charles, now in Tampa, we went there and picketed in front of the company. It was on prime time television, in the newspapers, the little David's fight against the mighty Goliath. Folks, I asked the company, after firing me illegally, pay me my termination pay, which for each year I worked 1 month's salary. They said no. Sell my home pursuant to the agreement. They said no. Pay my moving cost back to Michigan. No. They don't want to pay me nothing. Sign a release and get the hell out of there. I tried my best to survive. My wife at the time, with the 4 small children, was not working. I was unemployed. We had no means of livelihood like any other American who is fired from his job for no fault. I held out for several days, sent my dependent father back to India, and I flew around the country to look for a job in 2000, in not 2000, 1981. It was very difficult time. People can get no jobs. And there are all kinds of problems. The interest rate in the economy had skyrocketed to 21%. Never in the history of the United States. No buyers to buy homes or properties. The company won't do anything. They literally held me to economic ransom until I was forced to sign a release while I was in Michigan under extreme duress, coercion, and fraud. Folks, in order to sue any company by an employee, especially major corporations, you have to go through certain administrative procedure, which is called filing an EEOC complaint or Human Rights Commission complaint, which I did with the EEOC. The EEOC, under a deal worked out by them under the table with these companies, without investigating as required under the rules, issued me what is called a right to sue letter, without which you cannot bring in an action at the federal district court against these companies. That is one of the statutory requirements, which I did on a timely basis. And I sued these companies also within 6 months from the date of receipt of the letter from the EEOC. I sued them for $10 million, seeking punitive and exemplary damages and attorney costs. Soon after that, I engaged the services of an attorney from Chicago by the name Cyriac D. Kappil, Kappil, who was subsequently murdered at his law office. You might have seen articles about it. I didn't know at the time when he was murdered. Later on, folks, during the period Mr. Kappil was on board, the district judge by the name John A. Reed Jr., who died a couple of months ago, as per the press report, he ruled he is not going to dismiss the case on a motion based on the release, the affirmative defense of release. He held in his orders the defendant's motion to dismiss is denied without prejudice, and he proposed to conduct an evidentiary hearing. I wanted to show you folks a copy of Judge John Reed's order. Dated, it's on microfilm, and also you can see this in my documentary, David versus AT&T, and the complete documents. David, let me give you the web address. It is the web address is http:// David vsatt.com/letter/dot. Once you hit this web address, you get all the documents. This is the letter that I wrote to the Senate Judiciary Committee. This letter is marked, and I wanted to show you this particular letter. You can read this letter once. You can get a close-up of this. Once we done the recording, they will put it on. In the order, this order dated April 8, 1983. the Judge Reed ruled he is not going to dismiss the case. The defendant AT&T and Michigan Bell, they have the burden to show to the court that I signed the release freely, voluntarily and knowingly, a standard laid down by the US Supreme Court in a case called Alexander versus Gardner Denver Company, 415 US 36 52 footnote 15 1974. That's the document. Folks, we were happy the judge ruled that way. But during the last 33 years, such an evidentiary hearing never took place. You understand the gimmicks, folks? The defendant has the burden to show I quit the job. That is what he said, stated in the release. Did I quit the job? We have overwhelming evidence I was fired in the presence of my wife. She testified, so did I. Okay? So I didn't quit the job. The question is, did I sign the release freely, voluntarily and knowingly as laid down by the US Supreme Court in Alexander versus Denver Gardner? The defendant failed utterly, miserably failed to establish their burden. They questioned me for 4 full days. 4 full days. We call it, this is a deposition. Or in state courts they call EBT, or evidence before trial. They questioned me, keep asking questions, the same question, different ways, trying to get something. What they call legally, it's called a fishing expedition to get something. They couldn't get anything. They questioned my wife. They couldn't get any damn thing. The normal procedure, generally in the federal court as well as in the state court, is once the deposition is over, the parties know where they will be when you go for a trial. The parties are going to make the same testament. So they don't want to do it. This mafia corporation, AT&T, their tactics are worse than the entire mafia families, the Costa Nostra, Genovese and all these put together. Their tactics is more disgusting. They deployed another tactics. Folks, this is the court's order. They don't want to do any damn thing. They knew that they can't prevail. Folks, their next tactics was to bring in a woman. Her name is Anne C. Conway. When a party cannot prevail, they resort to tactics. These tactics work when they can influence the judges politically, economically, bribe-wise and other ways. Judge Reed didn't disclose to me or Miss Conway they are close family friends. The judge also did not disclose, or this woman, that she used to work for the judge as his law clerk at the Middle District of Florida in Orlando for 3 years. Neither judge nor this woman disclosed that they were meeting each other at their homes in private when the litigation was going on. Why the defendant decided to bring this woman without disclosing to me she's a friend of the judge, they were meeting each other at their homes. You have to understand, folks, what goes on. The judge had a moral and legal responsibility, as well as this woman who is now the chief judge of the Middle District of Florida in Orlando. She is herself a judge today. But she kept quiet. The judge kept quiet. No proceedings for 4 years. 4 years, no court proceedings. Except that the judge will schedule a status conference, not in the open court. Every time he went to the court, judge will say, "Come into my private chambers, Mr. David." So from 1982, I filed the case until 1986. 4 years. This judge did nothing, absolutely nothing. Okay? However, there were few status conferences. What is the problem? Judge John Reed conducting a Rule 42B bifurcated trial to determine whether the release is valid or not, as ruled by him in 1983, April 7. He won't do it. You know the reason why, folks. Judge knew, the defendants knew, they cannot prevail on the merit. I became suspicious. After seeing the pattern, I started my own investigation. My counsel, as I told you, Mr. Kapil, was murdered prior to this. I took over from him. I sent the judge a questionnaire containing 20 questions, seeking information. The judge will not answer that in writing. The sitting federal judge called me on the phone, a pro se litigant, to Yonkers, New York, where I was then living, and said, "Mr. David, I am not going to answer your questionnaire in writing, but I will give you answers over the phone." I told the judge, "That's fine, Your Honor. I would like to have your discussions tape recorded." The judge consulted the AT&T lawyers, the attorneys, the US, all the people, the courtroom clerk, and he finally agreed. Then he admitted, yes, this woman, Anne Conway, was my former law clerk. She's my close friend. I went to her home. She came to see me. We met in Atlanta. We met other places in private. Is it to exchange money for rendering a judgment in favor of AT&T? What is the deal under the table? Under the Federal Rules of Civil Procedure, Rule 1, a judge is required to conduct proceedings speedily and expeditiously. An evidentiary hearing or a trial to determine whether the release, a 2-page document, is valid or not will take maybe 15 minutes or 20, maybe half an hour, an hour. In 4 years, the judge won't do it. Why? AT&T had brought this woman to higgle and bargain. You understand the gimmicks going on? After this judge made this confession, I notified the FBI in Orlando. And I also sent a letter to the then Chief Justice of the US Supreme Court, Honorable Warren Burger, who was to many lawyers a terror because he did his job. So they don't like him. Apparently, it appears to me, based on my complaint, he directed Judge Reed to resign from the bench, and Judge Reed was forced to recuse and resign from the bench. I have a copy of the recusal of the judge. The order, this is dated 30th day of August 1984. So this document is the order of the recusal. You will have a close-up later on. Okay. The judge recused and resigned from the case without conducting an evidentiary hearing in 4 years. Folks, not only the judge recused, under the rules, existing rules in the federal court, if a judge resigns, becomes ill or dies, a case is reassigned to one of the other judges in the court. They don't want to do this. AT&T doesn't want this. They had made a deal with this judge, Judge John Reed, who is now died in February, I believe. They had made a deal with him. So they wanted to transfer the ball from Judge Reed to another judge in Tampa by the name Terrell William Hodges. I got an order from Hodges directing me to appear before him from New York to Tampa, saying that he is now the judge assigned to this case, come to my court. I went there by plane. Judge Reed Hodges was afraid of me. Although I don't have a parking ticket, I am not a terrorist or a wanted criminal, I'm a litigant. So when I looked at the notice board, they said, security required, additional security, as if I'm a wanted criminal. I'm a simple civil rights litigant seeking justice from a court. When I went to the courtroom, where the FBI agents, marshals, city, all the cops are surrounding me, sitting all the sides. There's a status conference before this sucker judge, Terrell William Hodges. He says, Mr. David, I'm the chief judge. I have the right to conduct your proceedings. I said to the judge, Your Honor, you have no right. I don't live within your jurisdiction. The cause of action did not arise here. I live in New York. Transfer the case to New York. No, Mr. David, no. You have to come to this court. I sent to this judge an identical questionnaire which I sent to Judge Reed. He won't answer, because he had far more conflict of interest than Judge Reed. Folks, I thought this man, he issued an order saying that he is going to conduct these proceedings in accordance with the same ruling and parameters as ruled by Judge Reed. Did he? No, folks. He doesn't want to conduct an evidentiary hearing to determine whether the two-page release is valid or not. So, the defendant AT&T and Michigan Bell, these are all deals under the table. The ordinary people don't know what's going on under the table in the federal court. These are thought to be the guardian of the people's faith and trust. But what is happening is, these are wolves in the lamb's coating guarding the hen house. You understand? Folks, this judge won't conduct a proceeding either, although his declared intention was that he will. In the meantime, these two mafia corporations engineered a device, a tactics. According to the tactics, the well-orchestrated tactics, AT&T dismissed a white man by the name McDonald, Orville E. McDonald, from their New Jersey facilities, who was an employee of Michigan Bell like myself, sent him back to Michigan. They gave him $12,000. Mr. McDonald, instead of going to the federal court, he goes to the state court. The state court says, Mr. McDonald, you must refund the money before you can sue. These all deals under the table. They go to the Court of Appeal, the State Court of Appeals. A one-man judge held, that's right, you have to refund the money. As soon as he issues a one-man judge's per curiam, unpublished order, The defendant AT&T obtains a copy from the court the same day, bring it to the Tampa court, tell this judge, Hodges, dismiss this case, judge. Mr. David signed a release in Michigan and you have to apply the state law. See the argument? The US Supreme Court says in Alexander, you have to determine first whether the release is valid or not. It is like the tail wagging the dog. Supreme Court gives one direction. The federal district judge, ignoring the Supreme Court's ruling, takes side with the state court's ruling, the one-man unpublished per curiam opinion, and without following any of the requirements, grants a motion to dismiss the case. See the gimmick. In the federal practice, those who are practitioners, those who are students, and those who are judges and law professors, you know that when a party files a motion, the other party is accorded 10 days' time to respond. What in this case this judge does is, as soon as he gets a copy of the Michigan court's decision in the matter of Orville McDonald versus AT&T and Michigan Bell, an unpublished opinion, they bring it to the court, he issues an order right away. He says these rules are for fools, Mr. David. We don't wait. We don't give you an opportunity to respond. He issues a 4-page order. Judge Terrible William Hodges, I call him Terrible William Hodges, issues a 4-page order. Now, I have a copy of the order here. In the order, this is dated October 27. October 27, it's a 5-page order dated 23rd October 1985. Now, when there is no trial, no hearing, how can a judge make the findings of facts? I'm just reading for the record of the listeners. The plaintiff, Mr. David, was employed by defendant Michigan Bell Telephone Company when he was transferred to Orlando, Florida to work for co-defendant American Telephone and Telegraph Company AT&T. Mr. David's duties in Orlando, essentially providing litigation support to the AT&T antitrust case, were not satisfactory to him as his supervisory duties in Michigan. When the antitrust case was settled, Mr. David expected to return to his old position in Michigan. That's the first paragraph. Then coming to the important thing. Although the parties disagree over the particulars of the ensuing events, Mr. David left the employ of MBT and AT&T. How does this judge conclude, I left? The issue is whether there is an illegal termination and Mr. David signed a release, and is the release valid or not. This man, without knowing the facts from the plaintiff, concludes by accepting the defendant's one-sided pleading. He makes the findings. Folks, the funny part of this is he says he is directing the clerk to dismiss the case without prejudice. Use the expression without prejudice. If I did not return the 50,000 these companies paid to me. The 50,000 means they paid 5,000 to the lawyer to witness the document. Okay, they didn't give me a penny more than what they originally offered and which I rejected. Okay, now this judge says he doesn't care about what the US Supreme Court said. He doesn't care a damn. He doesn't care a damn about the federal rules of civil procedure. He has to go back to law school, but he retired. I don't know whether he's alive or dead today. Okay. Now this judge, he says, I should pay back that money. Supreme Court says, in another case, the name of the case is, so folks, Judge Hodges of Tampa, then, I think he's currently in Jacksonville. He's a senior judge as per my research last time. He says in his order, he is going to apply not the US Supreme Court decision as stated by the first Judge John Reed. He is going to go by a decision rendered by a state court in Farwell versus Neal, 40 Michigan, Appeal 351, 198 Northwest 2nd, 801, 803 Michigan, Appeal Division 3, 1972. Supreme Court decision is 1974. So this judge says, hell with the Supreme Court, we go by the state court decision. See the tactics here. The judge is picked by AT&T through the deals worked out with Miss Conway and Judge Reed on his termination of employment or resignation, forced resignation. This judge, he is not going to apply the US Supreme Court rules, so these rules are for fools. Guys, don't worry. Mr. David, you have to return the money to the AT&T within 10 days from the date of this order, applying the Michigan state law decided in 1972, not the Supreme Court decision. Folks, in Supreme Court, in Dolores versus Aubrey versus Endergy Operations Inc., it's 112 Fed 3rd 787 reversed and remanded. The Supreme Court says, this is the decision of the Aubrey, you can Google it, you will get it. For your information, those who are not lawyers, you can cite Dolores, Dolores M. Aubrey, Oubre versus Petitioner versus Endergy Operations, decided by the US Supreme Court. The Supreme Court in 1998 says a Title VII and ADA claimant need not return the money at all to the employer at the beginning. If the case is settled, then whatever they paid, they can be adjusted. This judge, he doesn't care the Supreme Court decision. So, he orders the clerk of the court to enter a dismissal without prejudice. I'm reading the last sentence of his order. It is therefore ordered that Mr. David shall have 10 days in which to file proof of tender of the 50,000 to the defendant, failing which the case shall stand and be taken as dismissed without prejudice. Mark the word, without prejudice and without further notice or order. It is so ordered, done and ordered at Tampa, Florida, this 23rd day of October 1985. Is the Judge Terrell William Hodges' order disregarding Judge Reed's order to conduct an evidentiary hearing. Folks, that's not the end of the story. Now, according to the definition, a dismissal without prejudice is only an interlocutory order. It is a temporary order. It is not a final order to go to the appellate court, United States Court of Appeal for the 11th Circuit. Folks, you have to understand, if you've seen James Bond movie, you get an idea about what I am talking about. This mafia corporation had another deal. This time, the deal was with the clerk of the court. You understand? The judge orders the clerk to enter judgment without prejudice. What the clerk does, he enters a judgment on the merits. On the merit means parties were heard, witnesses heard, there was a trial, and the decision rendered on the merits. Was there any hearing in this case? No hearing, no trial, no witnesses heard. AT&T files a scrap of paper, and this judge makes the findings of fact from his hat, and he orders the clerk to enter a judgment without prejudice. We want this to be on the web. He says here, it is ordered and adjudged that the plaintiff takes nothing, that the action be dismissed on the merits, not on the without prejudice, on the merits. The clerk is manipulating, changing the order of the judge, the clerk of the court. His name is Donald M. Cinnamon. And the defendant, American Telephone and Telegraph Company and Michigan Bell Telephone Company, recover of plaintiff or David their cost of this action. It means the party who is suffering has to pay them money. You understand? That's not in the order of the court. See the gimmick, folks? Gimmicks. It's a deal under the table in the United States District Court. So the deal is with the first judge, second judge, Annie Conway, third judge. She was not a judge then. And now the clerk of the court. Now, folks, I'm not a lawyer. I'm a simple, ordinary man. I'm fighting my case because lawyers don't take this kind of cases. If you are involved in a car accident, the lawyers will chase the ambulance in which the injured person is taken. They will handle it because they get 1/3 of settlement. I used to work for another lawyer. He used to do this. He was subsequently arrested by the police, chained, and taken to the prison. He was bribing all the people. Okay? But in this case, this kind of cases, law firms don't handle it. If at all you persuade one to handle it, they want at least 100,000 retainer upfront money. How many people who are thrown out of job illegally can afford to pay the lawyer 100,000 contingency fee? Upfront fee, not contingency, upfront fee. And they will bill you 300 to 500 or more per hour. So once you run out of money to move, you've got to keep pumping. You understand the gimmicks going on in the United States courts? Okay, folks. Now, the attorney for the defendant, they are called, the lead attorney's name is Peter Zinneber. Lead counsel. The second attorney is Ann C. Conway. And the third attorney, her name is Kathleen S. Edwards. This is a copy of their pleading, the last copy, which we are going to show. You can see the close-up. They filed a jurisdictional statement. Jurisdictional statement is mandatory for the lawyers to file before they file brief. Here is a copy of the jurisdictional statement filed by these three lawyers who work for a law firm called Carlton Field, Emanuel, Cutler and Smith. That's the law firm in Tampa. These three lawyers, one of them is now the chief judge. They are filing a false jurisdictional statement which reads, the United States Court of Appeals for the 11th Circuit has jurisdiction to hear this appeal under the authority of 28 U.S.C. Section 1291, in that appellant seeks review of a final decision, of the United States District Court for the Middle District of Florida, which entered a summary judgment as to all of appellant's claims on January 9, 1986. Folks, this 5 printed page jurisdictional statement is false, because the order of the court was to dismiss the case without prejudice. The one who altered is the clerk of the court. You understand? Now, the purpose of altering the judgment the way the clerk did is to enable the defendants to have a smooth sailing at the United States Court of Appeals, where they had arranged under the table to have the case before a panel of their choice. You understand the name of the game? First, they lied. The clerk lied. They filed a false statement claiming the United States Court of Appeal has jurisdiction when it has no jurisdiction pursuant to Section 1291 of 28 U.S.C. Right? Now, they want to get this over so they can have peace. Nothing to worry about this guy. This sucker company, AT&T, this is the directory. When I was working, my name is here. This is the directory, AT&T directory, when we were working in Orlando. Now this company, in concert with these three lawyers who are working for the law firm of Carlton Field, Emanuel, Cutler and Smith, they lied, pretending they didn't read Judge Hodges' 5-page order. You understand, folks? Any lawyer worth his name should read the judge's order. Oh, we didn't read. We only read the clerk's order. See the tricks? People, you are smart. You are smart people. Understand the gimmicks going on. Folks, I got an order from the United States Court of Appeal for the 11th Circuit in Atlanta. Mr. David, you have 5 minutes time to argue the case before the panel. I flew into Atlanta, Georgia, to argue before the United States Court of Appeal. I was given only 5 minutes. I have 6 legal points to be argued. By the time I started talking, and I asked the panel before I started, Your Honors, I have 6 legal points to be argued. Give me additional time. Mr. David, proceed on. We will read your brief. You understand, folks? The panel members were Robert Vance, the judge who was subsequently murdered in the same year by one Mr. Moody. Moody, I don't know, research shows he was sentenced to be executed. Whether he is executed now or not, I don't know. But I'm sure, based on my research, this guy may have serious concerns for doing what he did. So Judge Vance, who affirmed, is gone. The second judge in the panel, his name is Allgood, Allgood, Allgood. He took a gun and shot and killed him. United States Court of Appeal, next below the Supreme Court of the United States, one judge is bombed and killed by Moody. The second judge took a gun and shot and killed him, not immediately, because he can't put up. He may be working as a pure mechanical instrument for the corporations. He can't do this anymore. So he took the gun and killed himself. The third judge, Larry Edmondson, the black guy. Larry Edmondson, if you Google it, you will see the allegations. The cronyism, the buddyism, favoritism. These three panels, after hearing my 5 minutes argument and reading my brief, issued an order. Okay? The order says, interesting folks, the United States Court of Appeal is required under the rules to make a de novo determination, de novo, fresh decision. It's a case, it's a statutory claim filed by a pro se litigant. The judge ruled to conduct a hearing, no trial, nothing. They concoct a story, they bring in a hatched case, and on the basis of this hatched case, the judge, second judge, Hodges, rendered a decision inconsistent with the standard laid down by the US Supreme Court. And these three suckers, this is the order, says one word. You argue the case before a panel, says affirmed. Affirmed. It means they don't want to address any of the issues you raised. If you say 5 and 5 is 10, Your Honor, the other parties no, 5 and 5 is 11. The judges say, affirmed. You understand how stupid these judges are. No wonder Moody decided to kill him, and the second judge decided to kill himself. Okay? These are men who are thought to be by the community, the Americans, as men of wisdom and integrity and reputation. What reputation and integrity these judges have? Affirmed. Nothing else. Affirmed. Folks, I moved to the Supreme Court of the United States. There may be bigger political game going on. You know the Gore decision in the election, when Gore took part for the presidential election. Supreme Court, they have a printing machine which says they put the name of the petitioner and the defendant, and the machine will say, certiorari denied. You understand the name of the game here? Lower court corrupt judges, appeal court, they fix the panel that will affirm what the lower court did. This is all insider game. United States Court of Appeal, District Court corrupt judges, the corrupt judge's decision goes to another corrupt panel of appeal court judges. They make no findings, no decision, all the issues you raised were ignored because you are pro se. You don't know the law, do you? Folks, I'm sure there will be jurists, there will be men of wisdom, there will be judges, law students, law professors, the public at large listening to my cry for justice. What's going on? I know what they are doing. I went to 3 years law school, not from the Columbia or CUNY or Yale, from the University of New Delhi. I know the fundamentals of law. I litigated 33 years. Folks, Supreme Court denied certiorari. I went to work for another law firm in New York subsequently. They have different tactics. Once you are fired, you fight back. Folks, as I told you, the US Supreme Court denied certiorari. Certiorari means they don't want to review the decision of the United States Court of Appeal for the 11th Circuit, which said affirmed. You have to understand, it's a Title VII case, ADA case, a breach of contract claims action. The lower court made decisions totally inconsistent with the standard laid down by the Supreme Court. Rule 9 of the United States Supreme Court rules state that when a decision of the district court is rendered inconsistent with the standard laid down by the Supreme Court has the authority to review that decision. But in this case, the district judge, Terrell William Hodges, makes a finding contrary to the US Supreme Court standard, relying upon a state court law which says I should refund the money. The Supreme Court keeps quiet. The Court of Appeal judges do not even say a word about it. They simply said affirmed. No opinion, affirmed. And the wonderful Supreme Court of the United States Supreme Court, despite its commands under Rule 9 that it will review such decisions, simply denied certiorari. Folks, 6 years later on, when I was working in another law firm in New York, I happened to read the Law Journal. The Law Journal clearly addressed the issue, what is a dismissal without prejudice and what is a dismissal on the merit. In this case, in my case, the order of Judge Hodges was to dismiss the case without prejudice, which was altered by the clerk on his own. You understand? So, when I discovered this, I filed another motion before Judge Hodges under Rule 59 or 58, one of the two, I can't remember now, asking him that the clerk entered a judgment inconsistent with his orders. His orders was to dismiss the case without prejudice. The clerk entered that as a dismissal on the merits, and on the basis of that false judgment and the affirmation of three attorneys working for Carlton Field, Emmanuel Cutler and Smith of Tampa, namely Anne Conway, Peter Zinabar and Kathleen Edwards, the United States Court of Appeal asserted jurisdiction, which it had no jurisdiction pursuant to USC 28-1291. Now the Supreme Court says so. So I asked Judge Hodges, Your Honor, you must amend the judgment. This is not what you ordered. Judge Hodges had no option but to ask the clerk of the court, to direct the clerk of the court to enter a judgment without prejudice, retrospective effect from the date of the original entry of judgment. So the Judge Hodges issued yet another 4-page order detailing the reason why he is now amending after the 11th Circuit issued mandate to amend it. Folks, the legal opinion I received was that since it was a judgment without prejudice, and this was corrected by the judge subsequently, I can refile the case. Folks, I filed in 1996, I suppose, refiled a new action against the same defendants. And I added my ERISA claim because you are entitled to ERISA benefits. ERISA stands for Employees Retirement Income Security Act, passed by the Congress, seeking pension from the employer. Under the vesting regulations of ERISA, as put out by the Department of Labor, I am entitled to pension pro rata. It means if I didn't put 10 years of service, I am still entitled to pro rata benefits for pension. This mafia corporation takes the argument in their pleading that Mr. David didn't work for us 10 years, so he is not entitled to pension at all. Now, the defendant, this mafia corporation, AT&T, this corporation, this sucker company, deployed yet another tactics here. They know they can't beat me because they know that I'm too smart for them. They secretly went and hired the chairman of the Democratic Party's Rules Committee, a black guy. His name is Ralph Curtis Dawson. Dawson, according to the web, he went to the Columbia School of Law. And also he went to study Yale. Okay, this black guy is the chairman of the political party, of the Democratic Party. And also a member of the disciplinary committee of the New York Bar. Doesn't matter how many gladiators this mafia corporation may bring in to fight against the little David. They got to have some basic legal arguments to prevail. So the deal is, the case is assigned to a woman who was appointed by Bill Clinton, a Democrat. Her name is Joanna Seibert. You will see her picture on the web, which we are going to do. And now the deal is between this woman, who is appointed by Bill Clinton, and the chairman of the political party. You understand? The deal under the table is between them. So, Mr. Dawson, the black guy, he is also a partner at an international law firm by the name Fulbright and Jaworski. They are Fulbright because they deploy the tactics, the fraud, which I am going to come to in a second. And that firm recently merged with another law firm from Britain called Norton Rose. So the new name of the law firm then was Fulbright and Jaworski, now Norton Rose, Fulbright and Jaworski. And this sucker, this Dawson, is a partner. So what he did, he deployed another tactics. Folks, this is a James Bond movie. Ideally, James It fits in all the parameters. How they deploy tricks, tactics in every court. Dawson says to his co-counsel, his name is Brian Wayne Tilker. You see the good-looking guy? We put the picture. Tilker, file a false affidavit. We can manage. Because under the rules, if you are challenging a document which is invalid, the party has to submit the original document to the court. You can attach a Xerox copy and say, this is the original of the Xerox copy. So this guy, Tilker, attaches a copy of the original agreement I signed. And he tells to the judge, Judge Seibert, this is his affidavit, Tilker affidavit. I'm going to show you in a second. He says, I have personal knowledge of the facts stated herein. I'm going to put that up, this Tilker's affidavit. Now, what I did was, folks, I did some simple research. When I did the research, I found this guy, Tilker, was born on May 5, 1979 in New York. 1979. You understand, folks? This sucker, who is born in 1979, files an affidavit to the federal judge saying that, Your Honor, I have personal knowledge on August 25, 1981, Mr. David signed a release in Michigan. How old he was then? 2 years old. 2-year-old kid. You will see his photo. He is sitting, he says, I have personal knowledge. Folks, what's this? 2-year-old kid living in New York files a federal affidavit, a sworn notarized affidavit to the federal judge, asking her to dismiss my statutory claims based on this 2-year-old sucker's affidavit, attorney affidavit. The fact he is an attorney today doesn't make any difference. The question is, in 1981, when I signed the release in Michigan, how old he was? 2. He says, I have personal knowledge about Mr. David executing a release in Michigan. Folks, that is what is called perjury. Perjury means testifying before a federal judge facts to which he is not privy. He had no knowledge. That is a hearsay evidence. No judge can render a judgment in a statutory claim based on a 2-year-old person's affidavit. Tilker made numerous statements in his 3-page affidavit. You can see a copy of it, which will be there on the screen, and in my webmail. Every document is there in the webmail. Tilker says the litigation, how they managed, how they got the judgment from the United States District Court, how they got the judgment from the United States Court of Appeal, the Supreme Court denied certiorari. It's all based on fraud claims. Judge's order, dismiss the case without prejudice. Clerk alters it. United States Court of Appeal affirms it. U.S. Supreme Court denies certiorari. Now this sucker repeats the same thing, which they lied in the district court and the Court of Appeals. Folks, if this bitch, Joanna Seibert, is a honorable judge, she's a prostitute, she's not a judge, she's a prostitute who prostitutes the United States Constitution. This bitch grants a summary judgment quoting verbatim at 12 places Tilker's affidavit as the basis for granting a summary judgment. Tilker said so, Tilker said so, Tilker said so. Folks, in 1984, before Judge recused from the case, we had a conference, status conference. In the status conference, there was a colloquy between myself and Annie Conway, who represented defendants. And the judge ruled there is a triable issue of material facts remaining in the case. When there is a triable issues of material facts exist in a case under the standard laid down by the U.S. Supreme Court in the trilogy of cases decided by it in 1986, no summary judgment can be granted, especially when the first judge says there is a triable issue. If there is no triable issue, yes, the standard laid down by the Supreme Court in the three cases, precedent setting cases, I am not going to read them out, it will not allow me because of the time constraints. Supreme Court says you can't grant a summary judgment when there are triable issues. The triable issue in this case is whether Mr. David resigned the job or he quit the job as stated in the release. Folks, you got to understand. So this slut, Joanna Seibert, grants a summary judgment to the defendant solely and only on the basis of Tilker's attorney affidavit. I promptly filed a notice of appeal to the United States Court of Appeal for the Second Circuit, which is in the next building, in the Foley Square in New York. Now, immediately there was an action. The decision of this judge is totally erroneous. She can't grant a summary judgment. She should have stricken Tilker's affidavit as sham and taken action against him for perjury, because they all belong to the political party, Democratic Party, of which I voted for 40 years, including President Obama at the first election. Today I have no faith in the political party because I know they are a bunch of crooks running the country. People have no faith. Ordinary men and women lost faith, like the Congress party in India. They lost faith in the party. Okay? So, Judge Seibert grants the decision. I appeal to the Court of Appeals. Immediately, the clerk of the court, these are all insider deals, immediately notifies me by an announcement in the Federal Register. The regular clerk who assigned the panel of judges is transferred. We got a new person by the name Anna Staglic. Anna Staglic is a clerk or a case manager specifically brought in to have the panel of judges of the defendant's choice. You understand the gimmick here? So, we get John Walker, who is one of the panel members, Rena Raggi, and Jed Rakoff. 3 judges. They rubber stamp like the United States Court of Appeal for the 11th Circuit did, without addressing any of the issues I raised on appeal. You understand the gimmicks, folks? You raise an issue in the appeal court. This is the district court, this is the Court of Appeal, this is the US Supreme Court. Here the game in the middle court. Deal here, nothing goes here. You understand? This is the name of the game. This is the United States of America. Folks, this panel simply affirmed, okay, without addressing any of the issues I raised. One of the issues I raised was, can a 2-year-old Tilker testify? Isn't it perjury? Can you enter a judgment based on a false affidavit of an attorney? No answer. Can a summary judgment be granted when there are tribal issues of material facts remaining in a case? No response. Okay? It is like the tail wagging the dog. Not the dog wags the tail. The US Supreme Court makes decisions, the court below does the opposite. Who is going to question them? It's a deal under the table. According to my last research some 10 years ago, this mafia corporation has spent over $25 million to defend and pay money under the table to the various court personnel, including these judges. You understand? Little guy like me, who is sweating here in India to get his pension, he can't even get that damn thing. You understand, folks? ERISA is a law passed by the United States Congress. ADA is another law passed by the United States Congress. Title 7 of the Civil Rights Act was passed by the US Congress. Did I get the benefit of the laws? What crime did I commit? You can be punished if you commit a crime. By trying to enforce the laws passed by the US Congress, you committed no crime. You try to enforce. You're not a criminal. I don't even have a parking ticket during the last 45 years and lived in America. I might have few. When I went to work in the court system as an interpreter, we put the money in the meter. When you come back, you run out of the time, so they give you a parking ticket. Other than that, I have no criminal record. You understand, folks? This mafia corporation, I am so mad. Believe me, I am so mad. This crooked corporation, they shouldn't be running this business. This is a spy agency of the United States government. Spy agency. Okay? They don't care a damn about what happens to the employee. My family life was shattered to pieces. I went through 1 divorce, 2 divorces. Folks, who caused all the problems? Did I do anything wrong? No. Folks, my next approach was asking the US Department of Justice to prosecute these suckers. Tilker, who filed false papers in court, knowing it is false, and Dawson, who caused him to file the papers. Rule NYCRR 1200 8.4 speaks about misconduct of lawyers. a lawyer cannot do certain things. They are clearly spelled out. We will show you in the NYCRR 1200, 8.4, what they are. So the Dawson knew what he was doing. He was using Tilker as an instrument to carry out his orders, being the partner of the law firm. Okay, US Department of Justice is headed by an Indian by the name Preet Bahara, B-A-H-A-R-A, Bahara. He's an Indian, son of a Sikh gentleman. He's the US attorney appointed by Obama. He's the one who prosecuted an Indian diplomat by the name Devayani Coppergate. She was an Indian diplomat. She allegedly filed a paper to bring her servant to the United States. She was arrested, stripped, naked. I see the video, 2 policemen holding her both legs and another woman putting her finger in her ass. What a disgusting situation. Okay? So on the video, in Google, you see the shit. Okay? This is the treatment to an Indian diplomat. Somebody is immune from prosecution under the diplomatic regulations. Even if she committed a crime, a murder even, they can arrest her. They did this to her most humiliating treatment. And who prosecuted her is this Indian guy, Preet Bahara. Now, my complaint against these 2 lawyers went eventually to Preet Bahara's office. Preet Bahara and Mr. Kennedy, I don't even remember his first name, you will see the document. He says, these 2 guys have not done anything wrong. You understand? The system of justice. One guy, he's the prosecutor, the Attorney General of the state of New York. They prosecute this Indian woman, Devayani, strip her naked and do all the things, all the shit. She's back in India, I spoke to her a few times. At the same time, these 2, the white honky and this black monkey, who filed the false papers, they say, this Preet Bahara, they have not done anything wrong. You understand? There is one thing, common thread. Preet Bahara went to Columbia School of Law, and so is Mr. Dawson. You understand the connection? One is the chairman of the party politics, the other one is the guy who works for the law firm, also a member of the disciplinary committee. So anything they do, it is not a crime. You understand? Folks, I didn't stop there. I reported these 2 suckers to the district disciplinary committee known as DDC. When I submitted the complaint, written complaint, George Dopico, the chief counsel for the DDC, says, Mr. David, we can't take any action against this guy, although he did what you alleged, because he's untouchable. It means the standard, the dual standard of justice. We can't touch him. So he files a motion before the appellate division of the New York State Supreme Court, appellate division, asking the judges, Your Honors, we have a conflict of interest. We can't investigate one of our own members who is a committee member. So, the court may transfer the investigation to another division. The New York Disciplinary Committee is so big, so they have divided that into Part 1, Part 2, Part 3, Part 4, 4 divisions. First department is New York, Manhattan areas. Second department goes to Brooklyn and other places, third and the fourth, different areas. So the five-judge panel unanimously ordered an investigation against Dawson. The special counsel says, Mr. David, we traditionally don't investigate lawyers who commit crimes. If you have any grievance, you have to go to the appeal court, which I already did. He says, they don't conduct the investigation. They didn't do it for the last 50 years, since the inception of the second department. Secondly, you should pay a docket fee to prosecute them. You understand? When you have an action pending in any court, you use the same file number or index number. That is what is called in New York, index number. Case number 1143/82. So 1143/82, both parties file papers. This sucker, Gildo, says, no, Mr. David, you got to buy another index to have this guy prosecuted. Okay? It's not action by me, I'm a complainant. Okay? The order was from a five-judge panel to investigate these suckers. They don't conduct any investigation. Now, Tilker, who filed the affidavit, false affidavit, he fled to Hawaii, the state of Hawaii. He started working there as an unlicensed attorney for a law firm there, Torkelson, Katzmoor and Hetherington. That's the name of the law firm in Hawaii. I wrote to the Hawaii bar about this guy's conduct. If he can file a false affidavit, win the case, walk away scot-free, he will do the same thing there. He is to be noted by the bar. He's a criminal. So the Hawaii bar says, Mr. David, Mr. Tilker is not licensed to practice here at the time, so we can't investigate. Secondly, his conduct occurred when he was in New York. So the proper forum to investigate against this sucker, Tilker, Brian Wayne Tilker, is New York. We can't investigate this guy because he committed a crime somewhere else. So they washed their hands off. So we have nothing to do with him. Okay, he became subsequently licensed to practice there. He is still practicing according to my last investigation. Now, New York bar says, Mr. David, Tilker is not working for us. He is not in New York, he is in Hawaii. Hawaii says we can't investigate, you have to go back to them. So, the first department, of which George Dopico is the chief counsel, he says we have referred this matter to our staff attorney who determined he has not done anything wrong. You understand, folks? A lawyer files false affidavit, and on the basis of it, he walks away. The first judge says, Tilker only made one false statement. It's excusable. That's the only mistake. He is making a false affidavit. It's a crime, punishable 5 years prison and monetary damages. So he, being a member of the law firm at that time, working for Obama's Rules Committee chairman, he has not done anything wrong. The first department says, no. Our staff attorney decided he hasn't done anything wrong. With regard to Dawson, they don't want to conduct an investigation. Folks, I wrote to the 5-judge panel who issued the order, asking them to find out what happened to their orders. And I told them we are going to put everything on the web. No response. Folks, you understand where we are going? I am an aggrieved employee who fought 35 years now like a brave man. Tomorrow if I die, I will have no grievance. I will die like a brave man, a hero. I will not be a coward. You understand? I am working, folks, on a movie based on the whole thing, the whole cover-up. I am short of funds, of course. Those who listen to me, tell your friends, and friends in turn tell their friends. To help me, you can send me an email. My email address is trdavid2009@gmail.com. My phone number, toll free from the USA, is area code 631-841-6222. I know my phones are being bugged and monitored because this spy agency, if they can monitor, including the Pope and 43 world leaders, they'll be doing it on my phone, tapping my resources, checking my mail. I know it. One of the attorneys who worked for the DDC, her name is Christine Anderson. She got so fed up what is going on there, the cover-up. She blew the whistle. How the DDC, the District Disciplinary Committee, suppressing complaints, allegations of misconduct, if it is committed by larger law firms and their attorneys. She blew the whistle. She appeared on television. You can Google her, Christine C. Anderson. Okay? There was another attorney, I forgot his name. He's a guy with a PhD. He said the same thing. So those who believe, folks, America is a wonderful land and this is the type of justice I am as a US citizen is getting, I can understand the type of justice you, whether you are a citizen, non-citizen, alien, visitors, you are going to get it. Folks, please, I told all the people, the last thing I could do was to ask US Senate Judiciary Committee to investigate. Little guy like me, who live on a hand-to-mouth with a paltry social security, I can't live even with that in India. Okay, I can't fight. I asked the committee of the Judiciary Committee, which is now headed by Republicans, and I told them before the election, the Democrats are going to lose, and that's exactly what happened. Now this committee, they have the right to investigate the corruption, the cover-up, what goes on there, how cases are fixed by the major law firms, paying the little guys, the court officials, the judges, the law clerks, like Annie Conway, Judge Reed, Judge Hodges. Folks, Seibert, these are all poorly paid federal employees. Okay? So they don't say we don't want the money. What Judge Walker did, the United States Court of Appeal judge, who affirmed in my case, he went to AT&T premises later on. He killed a policeman guarding the premises. You Google it, Judge John Walker. And the present media said, is the judge above the law? If you drive, you kill a policeman, you are arrested. An ordinary man is immediately arrested, handcuffed, taken to the hospital after kicking him or killing him or maiming him. Take his blood to make sure he is not having any drugs or alcohol in his blood. But Judge Walker, who killed this policeman, he got scot-free. How much he might have received from AT&T? Folks, this is a major corporation. This is a major corporation. If this corporation, which is also now having their offices in India, in Gurgaon, New Delhi, where I went recently to see them, okay, they should not be permitted to run this country. It's a crooked corporation. They should be arrested. The top officials, these crooked judges who are now alive. Annie Conway, she was the go-between the judges. She was the lawyer then, making the deals under the table. You understand? This is the United States of America. Folks, this is my fate. 33 years, a 75-year-old man fought in America. No justice. No justice. You research. Go into my webmail, which is addressed to the Senate Judiciary Committee Chairman, Chuck Grassley. Read that. The webmail address again is http://David DAVIDVS att.com/letter/dot. If you click that link, my whole complaint, all the exhibits, all the attachments will pop up. You press exhibit A, click that, the attachment will pop up. This is for your convenience and the convenience for the general public, the jurors, my jurors. Folks, you are my jurors. You render the verdict against this mafia corporation and the crooked officials in the Department of Justice. Justice Department must clean itself first. Folks, as I told you before reading part 5, the final chapter, you should read part 1, 2, 3 and 4, so you get, although there is a repetition, this is not pre-recorded, so this is coming out of my heart, from my mind, okay? It's an extemporary speech. I never prepared. I lived through this 33 years in America. As I told you before, I'm an American citizen, I'm a US citizen, I'm a British citizen. Now currently I'm also an Indian. I've become, under the new regulations, a citizen of India because I was born here and brought up here. But I want you folks, you talk to your senators, your representatives in the House of Representatives. Tell them what amendments to the law you should make to make it work, the aggrieved parties to get justice, instead of begging lawyers to take your case and you have no means to pay. If the laws have to work, if the laws have to have teeth, there should be an enforcement machinery available to the public free of cost. And these corporations who blacklist their employees because you are fighting for your life, you're fighting for justice, can't get it. Americans, many of them, they take the law in their own hands. Being an Indian, who was taught the principles of ahimsa or non-violence. I don't do that kind of thing, but Americans do. And if you want to have the slaughter stopped in the American streets, we should ensure, our Department of Justice ensure that they interpret and apply the laws for everybody alike, not a separate law for Dawson and Tilker, another law for Devayani, who filed the papers, allegedly filed the false papers. Tilker, who committed a crime, nothing. The Department of Justice washed their hands off. The 5-judge panel's orders ignored. You understand? People, you are aware, you are my jurists, and I submit to you, tell your congressmen, senators, amend the damn laws to provide for enforcement. No enforcement, Congress can pass so many laws. Okay? My case should be an example setting case. So you can quote David versus AT&T, how the game played all throughout the system, 33 years with no trial. Folks, that's the sorriest thing. I feel sorry for my brethren in America. I have 5 children, 7 grandchildren. They are all US citizens. I'm here because America may be a wonderful land, the cradle of democracy. But what I see is a mogocracy by the major corporations. That should be stopped. I'm not anti-American. I'm not anti-corporation. I'm a law-abiding citizen. Last 75 years, I did nothing. I fought for justice, for myself and for you. So, I want to thank you folks. Again, those who want to call me on 631-841-6222. The best time to call me will be in the evening, your time, which will be daytime in India. We are 10.5 hours ahead of US time, especially New York or Washington. Pacific time is further 3 more hours behind. So thank you folks. Thank you very much again. God bless America.